Leander Coates for the Attorney General's office, and we are here on temporary orders on confirmation of arrears and modification. So, Your Honor, back on June 11th, 2024, we did temporary default orders, Your Honor. At that time, Mr. Haygood was incarcerated, and so we had set child support and medical support to 0. And we also took judgments against him. Let's see. It was as of May 31st, 2024, we took judgments in the amount of $48,196 for child support, Your Honor, with a repayment of $291 each month starting July 1st, 2024. There was no medical support or dental support judgments. And so today, we are asking that pretty much the temporary order be finalized, except just updating the start dates of those arrears and the 0 medical, 0 child support to August 1st, 2025. The child is 18 and has now graduated, and so there is no need for that. Additionally, we had reset this several times, one to get like parties to appear because one party would appear or the other one hadn't found a job, and so it's been on and off, Your Honor. And so we weren't able to find any information with regards to work, and Ms. Copenhaver, I believe, will testify that she's not aware of any employment that he had between his release and then before today. Your Honor, I'm also going to show you the last reset we had, that Mr. Haygood was aware of this setting.
Did he sign it? Is that what you're saying?
Yes, Your Honor. I think I did the right one. Okay. This is our reset.
Okay, on the screen is a reset order for this matter. It was filed marked April 1st for an April 1st setting it for today, July 1st, 2025 at 10:30 with the correct Zoom ID. And it was at the bottom, you need a discovery is necessary to be produced. Who signed it? Mr. Haygood signed it, not Ms. Copenhaver. So he was aware of today's date. Okay, they'll support your default today. So tell me, okay, I guess you want to elicit testimony before you give me a closing. Okay, thank you.
Yes. All right. So, Ms. Copenhaver, have you had any contact with Mr. Haygood?
No, ma'am.
All right. And do you remember the last time you may have communicated with him?
The last time I actually saw him face to face was about 15 years ago. The last time a phone call, maybe 6 or 7 years ago, give or take. It's been a while.
Okay.
A long while.
So, you do remember when back in June, a whole year ago, when we did the temporary orders, you remember we did the temporary orders because he was incarcerated, but he was about to get released. Is that correct?
I believe so. I think that was back in October is when he got released.
Okay, October of 2024. I think that was the reason we were coming back. So let's see. So looks like we came back December 3rd, 2024. I would like to say that neither one of you appeared that day because I don't have your signature on that.
Okay.
So obviously we've had to reset to try to get both of you to appear, and then we also have reset to see if he's gotten a job. I have not received any documents, and I have no information if he's working, and was working before your child turned 18 and graduated. Do you have any information on whether or not that was happening?
No, ma'am.
And so now that your child is 18 and has graduated, my understanding is he graduated last month. Is that correct?
Yes, the latter part of May.
Yes. Now that your child's considered an adult and has emancipated, you understand why we're just asking that basically the temporary order just remain the same with just new start dates. Do you understand that?
Correct. Yes.
And do you have any issues with that?
No.
And I just want to double check. I'm pretty sure we didn't do a non-disclosure, but correct. Is there any reason that a non-disclosure is now needed? Is there anyone aside from Mr. Haygood, if they got a hold of your phone number or address that they could or have been harassing you, has anything changed since you last been
No.
in this court?
No.
Okay. And I think that's all I have. So, Your Honor, I don't have any further questions.
Okay, is there anything that you weren't asked that you think you need to put on the record, Ms. Copenhaver, for the facts of this case?
No, I don't believe so.
Okay, so tell me exactly what it's gonna look like with the same, you're updating the judgments too, or are you just,
No, Your Honor, we're going to leave
everything?
we're going to leave the judgment dates as of. The only thing is that instead of it saying July 1st, 2024, we're just going to say August 1st, 2025
for what? The
for the
start dates on,
start date for the child support judgments, medical support, dental, and then as well as the zero start dates, because it's been that same thing since June 11, 2024.
so the effective date of the, or the updated date on final order is August 1st for this, for the dates for payments, correct?
Yes.
But the
Yes, Your Honor.
judgments will still remain as of whatever date they were back then?
Yes, Your Honor.
Okay, and the amounts, and then the computer will fix it all and update it, the rest of it, correct?
Yes. And Your Honor already waived the court cost last time, Your Honor.
Okay, so they'll put that in the final order, and then, I don't know if you have to say this or not, but if it wasn't pled, you don't need to say anything. If it was pled, then no non-disclosure findings ordered.
Okay. Let me see.
Does
I'm
it-
sorry.
Yeah,
There was one small change. I didn't realize the child support officer had changed it, Your Honor.
what?
The child support judgment, the repayment was set to $600. So let me actually ask that. Miss Copenhagen? I'm
Yes.
sorry. I'm sorry. So temporarily the order was set at $291. However, since your child has emancipated and you haven't gotten any help once he was released, are you asking that the judgment for the repayment amount change from $291 to $600?
I don't believe so. I don't think so. The last lady that I talked to, I think she said something about $200. I mean, whatever y'all factor in.
Did it have a rollover provision? Is that what maybe triggered that? Now it's just the child support plus the arrears payment is now 600?
Your Honor, I think what she did is probably just calculated what child support would have been on minimum wage and then put it together. So and
Well,
that's like
yeah.
the 600, because in the temporary order it was just 291 because it was 0 plus 291.
Yeah, I get that. Okay, but yeah, you probably want a little bit higher. You think he's not gonna be able to do it? Is that what your concern is, Mr. Kaltenhaver, or what? You're not.
Well, not that he won't be able to do it. It's just he's never paid me anything ever. So even if I get $200, that's more than I was getting before. With his track record, he's in and out in prison all the time. You know, my expectations and hopes for him are, they're not set very high. So
Okay, well, sometimes
whatever you think.
Well, sometimes if we set it too high,
know.
they just say that forget that and walk away. But sometimes when it's, something they might manage, they might try. I think you're
Yeah.
a little bit right about that, but I don't, I mean, it's a lot of money and the interest calculation is what, Ms. Coates, on 48,000 is at least 240 a month, or your computer might show something different, but it's at least, so you probably did 240 plus $50 to get 290.
291,
Yeah.
yes, Your Honor, back then.
Yeah, I think that's too.
Whatever y'all think, I'm okay with.
I think I would double it. 250 and 240 plus 260 is 500 even. Just do 500 maybe.
Mhm.
Because this could last a long time. Y'all are young, but it goes very quick and the interest kicks in and keeps going. It doesn't forgive. The only way anything of
Yeah.
this goes away is if you go in and agree to forgive or release some of it or all of it, and you don't have to do
Yeah.
that, or he could owe you into his grave and be your retirement plan and even past that if he dies and leaves anything. But at least
Right.
Carter's, if the state's not opposed, 500 a month.
Okay.
Not opposed, Your Honor, so I can make that change, but they
And
should all be,
August 1st, okay. And I'm waiving the court costs. If he has any money, he should go to child support, and he was incarcerated for a while. Okay, and that you're done with him as far as current support now, it's just a matter of collecting, or if you know anything about where he's working, if you find out through social media or anybody, call it in, because they can research it and try to get withholding if he's got a steady job with us.
Okay. I also have kind of a weird question. Like I probably should know this answer, but after 15 years, I don't have a card or anything on like how I'm even supposed to receive child support if I'm ever
You either
in that
talk-
position to receive it.
Just go ahead, Harry, talk to the AG right now before you leave, or there's all sorts of things on the website. I
Okay.
think you have to just create an account, connect it to your bank, whatever there's electronic ways to get it. So there's not
Oh,
the old
okay.
fashioned way. Okay, so
Okay.
either talk to them, stick around for a few minutes afterwards, or you call them and get it over the phone or something, or just look it up.
Oh, okay. Thank you so much.
You want to stay and talk to her for a minute, Ms. Coates? Maybe that'd be the best or easiest.
yes, Your Honor, I'll,
Okay. Okay, then I think we covered all the bases, so I'll grant the judgments as previously ordered with arrears payments starting now or in the future, August 1st, and no court costs and no non-disclosure. I think that was the bulk of it, Ms. Coates.
yes, Your Honor, that was.
Okay. Then they're gonna draft it, send it to you by email. Have I said this already? I've said it several times today. Am I repeating myself? So check your emails maybe this afternoon or hopefully by 5. If not, keep looking. Anything coming from the Texas Office of the Attorney General is your priority homework to review the order and sign off on it if at all possible. If you do that quick, I get the order fairly quickly. If you don't, I ask the state to wait no later than a week to turn it in to me by next Tuesday if you haven't signed it by Monday. But again, I get it quicker if you sign it quicker, okay?
Okay.
At your request, I'm gonna ask you to stay behind for a minute. They can give you the information you needed, since they're the experts on that. I don't wanna tell you something wrong on the record. Okay?
Absolutely.
Okay,
Thank you so much.
thank you, ma'am. Then that concludes this hearing. I'm gonna stop my recordings and just give me a minute and then they'll transfer you back to a break room and talk to you there.
Thank you so much.
The intercodes for the Attorney General's office, and we're here on the suit affecting the parent-child relationship. For Reagan and Ancona, thank you. She is 3 years old. And Mr. Ancona was served, Your Honor. And we did share the citation off screen with Your Honor. And you feel like you can make decisions with Mr. Ancona with regards to your daughter's health, education, and welfare?
Yes, ma'am.
And you do not feel like you don't need your information protected, such as your email, your address, your phone number?
Yes, ma'am. I don't need that.
All right. Anything else the judge should know at this time that I didn't get to ask you that you feel is pertinent?
No, ma'am.
All right. All right, Your Honor. That is all the questions I have for Ms. Boyle and ask that you grant the terms.
Let me just get a little more background. How old is Mr. Ancona?
He was born in 78, so I think he's 48 to 45. I'm not sure.
Can't do. Oh, how old are you? He's a few years,
I'm 42.
he's a few years older than you. Okay, that's good enough. I hate to ask, but do you know whether the drug charge is he using or abusing or he was selling or?
He was selling.
Yeah.
We met each other in a difficult time in both of our lives, and it forced me to get responsible and clean up, and so I'm not holding it against them. We were both messing up.
Okay. I just want to protect the child, or make sure you understand what you agreed to before we put it in an order. Like if he gets out and he doesn't stick to the plan or the promise, and he's got all this access for visitation, including 30 days in the summer, do you really think he's going to pick up the child, or do you think maybe we shouldn't put this in the order if it does?
No, I don't think he'll actually come and get her or anything.
Okay.
If he decides to, no, he wouldn't do that.
He wouldn't do that.
But if he does, we will go modify very quickly.
Okay, well, just so you're aware of that, if it says standard visits, then technically you're under an obligation to obey the order too. However, I will tell you that if he's drugged and out of his mind and you hand the kid over, you might be charged with something for handing a kid over to a irresponsible or somebody who's under the influence of something, because if something bad happens, they'll drag you into it too for letting it happen. So
Yes,
yeah, if he shows up drunk or drugged and he shouldn't be driving off with her, you shouldn't be letting him drive off with her.
no,
Okay.
definitely not.
That's a backup. So just to tell you that, but if things go well and you're not under the same roof and this order has to be in play, you're pretty sure he'll be a responsible dad, and she'll be older by then, I presume.
Yeah.
Do you have any idea when he gets out?
No, I think it's not going to be for a while, so she'll be much older.
Do you know what?
Your Honor, I actually have that information.
Oh,
He's got a projected release date of January 16, 2027.
okay, so it'll be a few more years. Not that long, but okay. He didn't make parole or something earlier, probably not.
No, Your Honor.
And and I guess she said was correct. He went in 2021, so it was at least a maybe 6-year sentence or so,
Let me, 1 second, Your Honor. I have his inmate information.
5 or 6 years maybe.
It's a little bit more complicated than that. He actually has a federal charge, and so once he gets out of state, he will go to federal. So he won't be out till she's like 10.
Oh, okay.
So this is a
Just
PDF version of the TDCJ, Your Honor, the Texas Department of Criminal Justice, of Mr. Ancona's information, inmate information.
Okay. You scroll down, projected release, you said January 16, 2027. Eligibility was in 22, he didn't make it. Okay, but that does not have the federal stuff on it, so I get it. So
Okay.
age 10, you'll have another 7 years possibly, or 6.
Yeah.
Or 7. Okay, and they were for well, drug charges and possession of firearm. Okay, thank you, Ms. Coates. I think that covers it. Then, do you have any other questions or concerns that before we let you go, Ms.
No, ma'am.
Okay, and oh, the other thing I did want to tell you on modifying visitation, you said we'll do it in a heartbeat or in a minute. Yes, you
I
can.
know, takes a little bit longer.
Nothing's overnight with court, for one. For two, it's not this modification just for visitation is not something the AG does. It's not a service they provide. So you can't go through them just for that for free to us do it. I don't hear those cases, but you can modify visits, but you have to either hire your own lawyer or figure out yourself how to file and get into a courtroom and change the visitation. But that's what I tell you. They'll bring any child support modifications, yes. And if you might have an agreement on something else that I'm not going to touch, it's just an agreement you put on the record. We can possibly include something in an order, even if it were visits, but I wouldn't hear it as a contested thing. Just so, okay. And so it's not that easy, but it's possible. Anything else, ma'am?
No.
And Ms. Coates, anything else? Well, I guess, did you want to make a closing, or was your opening with the testimony enough? Because I think I have everything.
Yeah, so we just need your ruling on court costs, Your Honor.
Yeah, I'm gonna waive him. He can't pay child support. I don't think he can pay his court costs either. So I'll waive those, and you already told me there's no non-disclosure issues, and I will adopt the recommendation and by the testimony of Ms. Boyle, all the other matters regarding conservatorship support. Pretty much that's it. And the retroactive where there is none. Okay, that'll be rendered by default against Mr. Ancona. So now it's my order. Ms. Boyle, you can't walk away and not change your mind, come running back. It's too late. I've just said it's an order. It's set in stone now. There are other ways to appeal or do whatever you need to do. But otherwise, the state's going to draft this order, send it to you by email. You'll be checking your email for anything from the Texas Office of the Attorney General, maybe by mid-afternoon or probably by 5, possibly about 5, if they're not stuck in court all day today, maybe tomorrow. So I give it about a 1 week for them to draft it, send it to you, and you sign it and send it back. And if you don't, by next Tuesday, they'll be submitting it without you. Or if you sign it, it comes in quicker. So I expect them to get it out by today or tomorrow. Okay.
Yes, ma'am.
And is there nothing further? Then you're excused. All you have to do is click the end meeting button. You're done with court today. Thank you, ma'am.
Thank you.